Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision in the case of Karen McNeil versus Community Probation Services. In this case, we are dealing with an appeal that arises out of a lawsuit dealing with bail and probation, and we're attempting to hold the probation services themselves responsible for their component of it. So we're going to look to the degree to which the probation services can be held accountable for their participation in the bail system. So let's get started with this. This appeal arises out of a lawsuit challenging the way Giles County, Tennessee, determines bail, privatizes probation supervision, and collects fees. Last time we tangled with this litigation, the sheriff and county appealed a preliminary injunction stemming from the bail-focused claims against them. This time, a probation company and one of its employees appear the denial of the motion for summary judgment, raising immunities we affirm. Giles County contracts with two private probation companies to supervise the probation of people it convicts of misdemeanors. A putative class of misdemeanors both sued both companies, some employees of each company, the county, and the county sheriff. They allege the defendants have committed federal constitutional violations, racketeering violations, and state law torts. The plaintiff seeks injunction to stop the company's continued operations and damages for what's already happened. This appeal involves just one company and one employee. Community Probation Services and probation officer Patricia McNair raised qualified immunity and sovereign immunity defenses. We have authority over the appeal because denials of the anti-suit immunities receive immediate appellate review. So one of the first things you immediately note here is that these are private actors, but they are arguing government defenses. They're arguing qualified immunity and sovereign immunity. Those are government arguments. One of the things you would look to determine this is whether or not the private entity is actually a government. And to determine that, you look to, among other things, how they act, their interrelatedship, and the stuff they perform to determine whether or not they're performing government roles. So, you can't get outside of this, outside of government action just by doing it through private entities. So we have to look to see whether or not these are private entities or actually the government. So let's read on. Qualified immunity partially, though not completely, protects government employees from personal liability for actions. In invoking the defense, the company and McNair trip over the reality that they face no damages of prospective damages liability. Start with the company. The complaint does not contain an individual capacity claim against the company, nor does any feature of the course of the proceedings. On top of that, the plaintiff has represented repeatedly and expressly they do not seek to hold the company individually liable for the damages. What should we make of the reality the company counters? The plaintiff seeks putative damages. It is true that putative damages are not available against counties. It's true in some instances courts have repeatedly treated a request for putative damages as indication a suit seeks individual liability. But none of this alters the equation given the plaintiff's express representations that the company faces no liability. Even so, the company asks, what should we make of a second reality? The plaintiffs have amended their complaint twice and have yet to clarify the company does not face money damages. That is true. While it does not alter what they have clarified, in 4 separate filings, they insist they do not seek damages from the company. Judicial estoppel will prohibit any change of heart now. So among other things, we're looking at different things in different filings. And so the company is saying, well, look, they never amended their original complaint to take us out of it. Well, it's like, well, that's true. But they said in 4 other filings that it's true. So even though they haven't changed it in their original pleading, they have created an estoppel, which is, to prevent them from changing. They've already made representations, and we're going to stick with it. And this may or may not be comparable to the issue in the Vic Mignogna case, because to the degree to which certain representations were made and those were defied upon, you can't then look to other things. It's like, it's an issue of estoppel. It's once you make representations to a court, they're binding. So, you have to look to the whole picture. Now consider McNair. She seeks qualified immunity on all the 1983 damages claims brought against her. In response, plaintiffs represent they have not asserted any 1983 claims against McNair. There is good reason to take their word for it. Our review of the complaint confirms as much. Not a single claim against McNair appears in it. McNair worries that 2 features of the complaint cast doubt on the conclusion. She points out the complaint she's being sued in her individual and official capacities, but that language alone does not create a 1983 claim, especially in face of the plaintiff's disavowal of such a claim. All in all, the plaintiffs have not filed individual capacity 1983 claims against the company or McNair. No qualified immunity defense thus applies to them. So we're seeing some problems in the pleading. We're seeing some problems in the way it was argued. It's like, you don't even have to raise these arguments. There's nothing here for you to raise arguments against. So it's like, you don't need to raise a defense because you were never implicated in the first place. Okay, it sounds like some problems with the drafting to me. The company argues that if any claims targets its official capacity, sovereign immunity bars claims for monetary relief. Sovereign immunity, however, protects states, not counties. The question is that whether the company acts for the state or the county. The key consideration, who pays a judgment, predominates. In this instance, no one claims the state as opposed to county would pay any judgment. That puts the company in the hole to start, and things do not improve from there. Another consideration is who handles the misdemeanor probation in Tennessee. The state statute assigns responsibility to misdemeanor probation to counties. That suggests the counties would pay any judgment. So there's no sovereign immunity here, because even if you're the government, you're the wrong kind of government. So that's fair. All factors considered, Tennessee private prohibition companies do not act for the state and thus may not invoke Tennessee's sovereign immunity in the lawsuit. Reinforcing this conclusion is more of a concrete reality. We know of no case in which a private probation company has successfully invoked sovereign immunity. That leaves a few ends. The company and McNair devote 2 sentences to arguing their entitlement to witness immunity, and they dedicate a single paragraph, mostly block quotation, to quasi-judicial immunity. But they do not explain which claims these immunities were foreclosed or why they would apply. Both arguments are foreclosed due to insufficient development, and we affirm. So that is the end of our coverage of this case. In this case, we learned that Community Probation Services was sued for various things, but they weren't sued very well. The complaint was not well done. And so the company says, oh, we have responsibility, and the court's like, no, you don't, because they failed to really do anything in their complaint. They failed to allege against you. They made all these disclaimers on the record. There's no problem. So, none of this applies to you. So, it's good for the parole services, I guess, but not so great for the person who drafted the original complaint, because apparently they failed to such a degree that, basically there's no complaint at all. So that is the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.